All right, Chapter 21, Part 5. This is the last part that we have on this chapter. So what are some of the defenses to employment discrimination? Once a plaintiff succeeds in proving the discrimination, the burden shifts to the employer to justify the discriminatory practice. There are four basic types of defenses: a business necessity defense, a bona fide occupational qualification, a seniority system, and after acquired evidence. The business necessity defense requires the employer to demonstrate that a job qualification is reasonably necessary to the legitimate conduct of the employer's business. So hiring somebody as a bus driver, if the person is blind, then that would be a business necessity. You got to be able to see to drive a bus. And it's a defense to disparate impact discrimination. A bona fide occupational qualification. Here the employer must prove that the discrimination against a protected class is essential to a job, a bona fide occupational qualification. This is again the example I gave you earlier of the restroom for men and women and the attendant in the restroom. That would be a bona fide occupational qualification. Race, color, and national origin can never be bona fide occupational qualifications. Generally restricted to gender and religion. As I said, dressing room attendance. Seniority system is another exception. Such a system conditions distribution of job benefits on length of time that one has worked for the employer. It's a defense only if it is a bona fide system and not designed to evade the effects of discrimination laws. So in other words, if your workforce is primarily white at the higher level of years of employment and black at the lower levels, the lower years of employment, a seniority system may act to continue discriminatory actions and would not be a defense. Another possible defense is after acquired evidence. So this is a situation where the employee files a lawsuit on a valid discrimination claim, but the employer discovers that the employee did something that would have authorized the action, whether it be termination or whatever, and would not have been based upon the discrimination. So for example, the employer discovers that the employee was stealing employer property. That's an after acquired evidence. It doesn't shield the employer entirely, but may be used to limit the amount of damages that the employer is liable to pay. Now what about affirmative action programs? Affirmative action programs generally were used to make up for past patterns of discrimination by giving preferential treatment to protected classes. Title VII doesn't require or prohibit them. And they've been very controversial since they started, probably back in the 70s. And sometimes have been found to result in reverse discrimination. Okay, affirmative action programs where you're talking about a government actor may violate the 14th Amendment because of its inherent discriminatory nature. A program, affirmative action program, would pass constitutional muster only if it is attempting to remedy past discrimination and does not use quotas or preferences. So this enables an employer who has a past history of discriminating against a particular group, let's say against African Americans. They can adopt an affirmative action program in order to remedy that past discrimination so long as it doesn't use quotas or preferences. Okay? Alright. Once a program has succeeded in remedying past discrimination, it has to be changed or eliminated. Some states have adopted laws that prohibit affirmative action programs in their public institutions like colleges, universities. The Supreme Court has said that that's okay. Okay, and that's the last slide for Chapter 21. Again, the magic phrase is Title 7, and I'll see you again in the next chapter.